Hear ye, hear ye, hear ye. The Supreme Court of the state of Oklahoma is now in session. God save the United States of America, the state of Oklahoma, and this honorable court.
Good morning. Please be seated. In the Supreme Court of State of Oklahoma comes on for hearing cause number 123179. Stephen McVeigh, Amy Serrato, Kenneth Setter, and Anthony Staub versus Ben LePac in his official capacity as interim Oklahoma Secretary of State, and Getner Drummond in his official capacity as Oklahoma Attorney General. Will counsel for the petitioners make your announcements?
Randall Yates for the petitioners. With me at counsel's table is Melanie Regani.
Thank you, counsel. For the respondents?
Zach West with the Attorney General's office, representing both the Attorney General and Secretary LePac. And I've got Gary Gaskins with me, our Solicitor General, and three assistant solicitors, Ellen Carr, Will Flanagan, and Colin Sweeney.
Very well. Thank you, counsel. Petitioner, you're recognized for 16 minutes.
Thank you, Your Honor, and may it please the court. The first provision of the Oklahoma Bill of Rights declares that all political power is inherent in the people. And the first power reserved to the people in the Oklahoma Constitution is the power of the initiative, the power to propose laws and constitutional amendments independent of the legislature. This court has called the initiative right a fundamental right, a right to be carefully and zealously preserved to the fullest measure of the spirit and letter of the law. Senate Bill 1027 fails this exacting standard. It does not preserve the right, it frustrates it at every opportunity. It imposes county signature caps that denies the right to otherwise qualified, legal Oklahoma voters. It installs a government gatekeeper to control core political advocacy, and it layers on restrictions in circulation, funding, and reporting to make the process so burdensome that it would be unrecognizable to the founding generation. Like every other constitutional right, the initiative right is not absolute, but that truism is no blank check to the legislature. Whenever a law impedes a constitutional right, we hold that law to its constitutional burden. This court has said that no rights guaranteed under the Oklahoma Constitution shall be curtailed by legislation or any undue burdens placed thereon. Senate Bill 1027 does both. Even before 1027, Oklahoma had one of the most demanding initiative processes in the nation. It requires among the highest signature thresholds anywhere and allows by far the shortest circulation period at just 90 days. On top of that, there are many existing safeguards to protect against fraud and corruption. Every petition form is verified under oath. There are criminal penalties for false signatures and open judicial protest periods. These protest periods are initiated by the citizens, not by the government. And with these safeguards in place, over the past 25 years, there have been 11 votes total, resulting in just 5 laws. That is where we are now. A process that is stringent, stable, and most importantly, free from any finding of corruption or abuse. And none of these safeguards are going away. So Senate Bill 1027's new provisions will only drive those numbers down. They shrink the pool of eligible signers, drive up costs, cut off funding sources, and narrow the available workforce. They layer new administrative burdens, remove incentives for participation, and even place government in charge of the message itself. Every layer compounds the next, ensuring that a process that is already difficult to navigate will become harder for Oklahomans to use and far less likely to succeed. Measured against that burden, none of the state's asserted interests justify this law. The state claims an interest in promoting geographic diversity, but it relies on denial and redistribution of the initiative right. They say if some are disenfranchised, others are franchised in their place. But the Constitution recognizes no such trade-off. Lawmakers may not restrict or diminish the political voice of some in order to enhance the relative influence of others. Under the Oklahoma Constitution, every legal Oklahoma voter who can vote on the measure has the constitutional right to sign an initiative petition placing it on the ballot. The test is no more complicated than that, and this is not a balancing test. The legislature cannot deny this political right to any legal voter, period. Likewise, every time the Secretary of State would block a measure from ever going to a vote of the people based on its contents exceeds executive authority. And as the state now concedes, the Buckley-Meyer framework controls here. And that means at least two things right off the bat. First, petition circulation is core political speech entitled to the highest level of First Amendment protection. And that means at least narrow tailoring based on real evidence, not speculation. And second, that ballot measures present no quid pro quo or undue influence dangers, as would be the case in an election campaign. And for this very simple reason, no matter how much money you spend, you cannot trade favors with a ballot measure. And yet Senate Bill 1027 piles burdens on petition circulators, and them alone not faced by any other political actor, regulating the most at the precise moment when the state's interest is at its lowest ebb as a matter of law. Other than the quota system, the state offers only conjecture and hypothesis, not real evidence of a real problem. And even assuming a legitimate interest, Senate Bill 1027 is neither necessary nor narrowly tailored to achieve it. In the 60 pages of briefing, the state never tries to show narrow tailoring or that the legislature gave any thought at all to preserving this right. That is its constitutional burden. Instead, the legislature relies on broad deference and plenary power over the initiative right. But that cannot be correct for three reasons. First, the initiative power is a constitutional right. It expressly belongs to the people, reserved from the legislature. Second, it is a check on the legislature, not subject to it. Deference here makes no sense. If the legislature can regulate that check away, it becomes meaningless. And third, the initiative process is the people themselves acting in a legislative capacity. When the question is legislature versus legislature, deference belongs to the people because that is where the inherent authority lies. Here, if careful preservation to the fullest measure of the law means anything, it means that Senate Bill 1027 must be struck down in its entirety. I welcome the court's questions.
Thank you, counsel. Vice Chief Justice.
Good morning, counsel.
Good morning, Your Honor.
All right, I want to start out first with your level of scrutiny arguments. So I just want to point you to where I'm going. Specifically, I'm interested in the cap measure. I believe heard you argue that, and I think your briefing argues, that it would be a heightened standard because of the equal protection issue that you're raising, which means strict scrutiny applies. Is that correct?
Yes, Your Honor.
Okay. If that is true, I also heard you say, I think, that this level of scrutiny must be that they must show this, right? This compelling interest and how it's so strictly narrowed through evidence and not speculation. Is that also true?
Yes, Your Honor.
Okay. You brought this lawsuit at the Supreme Court, not them, correct?
Yes, Your Honor.
Okay. Do you also agree that the Supreme Court has concurrent jurisdiction as well as that of the district court? And at the district court level is where evidence can be presented and collected?
Yes, Your Honor. The record that matters here, Your Honor,
but you just said it has to be evidence-based.
Yes,
so
Your
if
Honor.
there is no, if it's your decision to bring this case here, which Blisi juris, as you know, I have a specific opinion about. If it's purely legal, then of course, and all the other tests we have to do. Here, I'm interested next in the question of, since we're arguing about the level of scrutiny, do you believe that that is a first impression question for this court at this time, since we're arguing about it? In other words, this is the first time we're going to say, hey, when someone's trying to challenge this provision of the Constitution, we need to establish that it's an equal protection clause problem, and we need to announce that we're going to be applying strict scrutiny. Is that new today for us, or are we just arguing about it?
It is not, Your Honor. The standard has already been set by this court that under the Oklahoma Constitution, the initiative right is a fundamental right, and when there is a disparity of treatment among Oklahoma voters, as there is when somebody is below or above that line, we subject that law to strict scrutiny. But my primary argument on the county caps is that this is a structural argument, that this is a violation just for denying that right to a legal voter. I think that was clarified in the 1936 case where they brought a challenge to a law that said, hey, if you can, there was a challenge to a law that it had to be registered voters that could actually sign. And this court was basically, why are you challenging it? That is what the law is. So that determines who holds that right. It's every legal voter in the state of Oklahoma. And if you deny that to any legal voter, it is unconstitutional.
Okay, let's talk about that just for a second. I heard you, I took a note that says they can't regulate it away. That depends on the interpretation, I think, of two clauses in the Constitution. First off, the legislature has the authority to, quote, make suitable provision for carrying into effect the provisions of Article 5. And then the next clause that we are arguing about, of course, is that maybe it's just a way for them to make sure there isn't fraud or corruption in the process.
Yes, Your Honor.
Okay, so when you are arguing that they can't, quote, regulate it away, let's focus on that for a minute. Do you agree with me that the initiative petition process that you very eloquently described is a, quote, way for our founding fathers who were populists to say, we don't trust our Republic Democrat form of government, meaning representatives from each area of our state, because they could be corrupt. So we need to make sure the people have the power, if we're worried about that, to bring things to the forefront. Would you agree?
I think that's part of it. Sure, certainly corruption could be, but it could just not be responding to the will of popular majority. So that's two ways that it's a check on the legislature, Your Honor.
Okay, so you believe that the founding fathers also wanted to, say that second part again, outside of corruption, they were worried about putting minority interests in front of the people?
No, just not responding to the majority. That's basically the foundation of direct democracy. And at the founding of this state, that was going to be central to the way that Oklahoma would operate.
I appreciate you clarifying that, because I misunderstood what you said. I appreciate that. So what I'd also like to ask about then is, can you tell me if I'm going to give you an example. If we have a Republic Democratic form of government with the legislature that has representation throughout the whole state, which is important, and then we have this other movement that says, but the people have a right to have what the majority of the state wants, and we want to be free from corruption if something happens with big business or creepy railroad people that back then, right? We want the people to be able to help make that decision. Do you think that if there is evidence base that the population shift since inception of our state constitution has actually inversed or flipped the initiative petition policy? And I'll let you answer that first, so I don't ask you a million questions at once.
Absolutely, Your Honor.
Okay.
And I think that if you're saying that things have changed from the founding that it would make sense.
Right, because your argument is it says at large, so in any voter, any legal voter,
Yes.
so there's no caps, so yes.
Yes, so if that were true and things had changed differently, certainly the state could do it, but it would have to be through a constitutional amendment restructuring the government, not through legislation, Your Honor.
Okay, you carried into my next question, thank you very much, and that is, it would have to be by constitutional amendment of the people, and that is assuming that your argument about the phrase, the legislature has the authority to make suitable provision for carrying into effect the provision, meaning the effect of the initiative petition is for rural voices to be heard, that the majority of what the state wants is heard, and therefore, you would argue that that provision still doesn't give the legislature authority, it can only be amended by constitutional amendment. Do you understand my question?
A restructure of the government would have to be done by constitutional amendment.
Okay, it can't be that the legislature is trying to protect the carrying out of the effect of an initiative petition, which would be rural voice, majority needs, and to fight any corruption at the legislature. If that was what was proven in evidence, that there wouldn't be a compelling interest by the legislature to legislate that through that provision to make sure the initiative petition policy is actually in play, your argument would be, yeah, that's not what that means in the Constitution, and if it is what the people wanted, it would have to be by constitutional amendment. In other words, the people could come in and put the caps in if they wanted to vote that in, right?
Yeah, my position is that the suitable provision clause has a very narrow meaning, and it means what it says in the text, and that we can't read extra things into it based on subjective purposivism or anything like that, is that we go with what the text says. And this text grants them specific authority, suitable provisions for what? To carry into effect the provisions of this article. And so you have to start with the constitutional text. You have to take a step back and go, okay, what are the provisions that need to be suitable? And so if you look at what the Constitution tells them to do is that, okay, there has to be an 8% threshold. This has to be filed with the Secretary of State. The entire measure has to be made available to the people. That's the starting point, the text of the Constitution. And then you make suitable provisions for those things. And those are all, they're very ministerial. They're very facilitative. Let's make rules that make this process that we've articulated through the text of the Constitution, let's make it workable.
Okay, I
just
just have one more question. I know everyone's probably like, why will she not stop talking? But I have one more question, and that is, it says carrying into effect the provisions of Article 5. Do you believe that that means all of Article 5? That clause applies to all of Article 5, the provisions of Article 5. And if not, why not?
Well, I think that it does, but it is limited to in the context of the initiative and referendum, because it is in Article 5, Section 3, that suitable clause provision, and 1 through 8, which is the clauses that this court said are the ones that need to be read together, that it's limited to the initiative process, Your Honor.
Okay, thank you, sir.
Thank you,
I
Your
waive,
Honor.
Your Honor.
Thank you. Justice Winchester.
I waive, Chief.
Justice Gurich. I'm sorry, Justice Combs.
I'll waive for Justice Gurich.
Justice Gurich.
That's not what I was trying to do. Well, I appreciate what our Vice Chief has gone through, because there are a lot of issues that I think were important and gave you a chance to speak to. I want to focus on this evidence-based. You brought this up. What evidence do we need? Are there factual issues in dispute here?
No, Your Honor. We believe that this is purely a facial challenge on this. We say that every time a county cap is applied, regardless of facts, it's going to deny the right to a legal Oklahoma voter, or that every time the Secretary blocks a measure from going to a vote of the people, it exceeds executive authority, or that the state's redistribution theory is a non-starter as a matter of law, and that if you take the Buckley and Meyer framework and you balance those two things together, you already have the legislature and the attorney general both weighing in. We already have a record that shows the enormous burden that 1027 places on the initiative right. All that's left for this court to do is balance those two things. That balancing is something that this court can do as a matter of law, and that's exactly why we chose this forum to bring our claim. This court's superintending authority exists precisely for matters such like this, a matter of public right where there's a pressing need for resolution on a pure question of law.
Well, I had some concern about, throughout the briefing, there's a lot of discussion about declarations that are part of the appendix. And so it's like both sides papered the file with affidavits, which sounds very evidentiary. We're old trial judges, some of us up here.
Absolutely, Your Honor. There is a record, and we did build a record to show that the burden that has. Once we show that burden, the burden of proof shifts to the state, and they're the ones that have to make this heightened showing. So you look at the evidence that they've presented here. But what the Supreme Court has said, and I just want to follow up on this, is that the record that matters when you're talking about asserting a state interest that burdens a constitutional right is the legislative record. And here, not only do we have a legislative record, it's not that it just says nothing. There is an express disclaimer of any finding of corruption, abuse during the floor debates, which we cited in our brief that you can take judicial notice of, Your Honor.
All right. So the gist is another issue that you brought up and has to do with, we know in the Constitution that there's a provision that the governor cannot veto any measure voted on by the people. And yet the Secretary of State is appointed by the governor. But you're challenging this based on speech, that this is government control of speech. Could you go into that a little more detail?
Yes, Your Honor. I think if I could first just address the separation of powers that you first brought up, is because I think that if I were to articulate a test for the court that comes from the text of the Constitution, it would be more helpful to resolving this case. And so here's the test that I think we should apply for the separation of powers argument. And so the executive functions cross into the legislative and judicial realm when the law allows the executive to examine the contents of the measure, and that's going to be an important limiting principle here, to make policy judgments and independently interpret the proposed law and block the measure from ever reaching a vote of the people based on that examination of the contents. That's inconsistent with Article 5, Section 3 that says that these petitions shall be submitted to the people. And I think this comes directly from the text and structure of the Oklahoma Constitution as you started to mention about the governor's veto power. So we start with the premise and the common thread throughout the Constitution that the framers wanted to insulate this process from the political branches. And so we know this from the reservation of power in Article 5, Section 1, and the removal of the governor's only legislative power, the veto power in Section 3. So at the same time, there is a specific role for the Secretary of State consistent with Article 6, Section 17. And this is purely ministerial. It's things like publishing, record keeping, certifying, filing. That's exactly what Article 5, Section 3 says. And the important thing to take away from this is that none of these functions required the state to examine the substance of the proposed measures or to make any judgments based thereon. So once he starts interpreting, judging, and blocking, he's exercising powers that the Constitution reserves to the court or to the people themselves. And then getting to your question is, that same authority that is given to the Secretary of State carries with it profound First Amendment consequences. The gist statement is inseparable from the direct one-on-one communication that Buckley recognized as core political speech entitled to the highest level of protection. In NIFLA, the Supreme Court said that the government may not inject its own speech into private advocacy in a way that alters the core message. That same principle applies here. So the question is not whether the gist is or is not government speech. It's that government speech doesn't belong there in the first place. So think about what the government is asking. In order for the people to exercise their check on government, they must first deliver a government message. That crosses the line set in NIFLA. So by arguing that this is government speech, state is not defending the law. It is conceding that it has unconstitutionally commandeered the message and is altering it at a point of advocacy.
All right, you mentioned that you didn't that we should strike this in its entirety, yet there are provisions in this act that would probably pass constitutional muster, aren't there?
No, Your Honor. I think that
not,
every one is designed to burden it, and there is no justification at all on the legislative or the judicial record. But I think that if you want to talk about severability, severability is about deference to the legislature. And I think here that the legislature, because it is the check on them, is not entitled to the same deference as they would get in other contexts. I think if you stop short of striking this down in its entirety and just pick and choose, you're allowing the legislature to kill this right through death by 1,000 cuts. You're telling the legislature you can take the cooked pasta approach. Just load this up with as many minor burdens as you can, throw it against the wall, and see what sticks. I think anything short of striking it down in its entirety would not be faithful to careful preservation of the law.
Thank you. I wait.
Justice Combs.
This may be oversimplified, but I take it your entire argument is that what the legislature has done here is to create some additional steps in the process. They've made it more difficult to circulate an initiative petition, correct?
I think that's the first step of the analysis, is that they've burdened the right.
Very simple terms. And what we're talking about here is circulating a petition. The
Yes.
first step in getting it to the point, hopefully, where the people can actually vote on the proposal.
Yes, Your
Right?
Honor.
So if we create more steps, we create more burdens, correct?
Yes, Your Honor.
And at what point does it become an undue burden?
That's a good question, Your Honor, and I think that we apply the same sort of test that the Supreme Court applies when it does heightened scrutiny. When it talks about core political speech that's entitled to the highest level of protection, and you do a balancing test there. What this court says is zealous protection to the fullest measure of the law. So that's ending up in kind of the same place as the Supreme Court. You do that balancing test, but the thumb is heavily on the scale of the constitutional right.
And probably none more so than the Secretary of State's authority under this act to rewrite the gist, to give it an up or down approval, which is something that we don't currently have in the law. The gist can be challenged currently, and it has often been challenged. There's a process for that, but it's not the executive branch doing it, correct?
That is correct, Your Honor. I agree with you. I think that that is exercising legislative judgment when you're telling the people how to describe their own measure.
I waive, Chief. Thank you.
Thank you. Justice Darby.
Morning, Counsel.
Good morning, Your
I
Honor.
want to go back to severability just for a second. And I was looking at the response, and they have bullet points. You don't need to really pull it up. I counted 15 further restrictions that they've listed.
That sounds accurate, Your Honor.
So I picked one of the more benign. Let's say signatories must identify their county or residence. That's not really a big deal. Tell me what you think the law is, what you would argue the law is about severability. Because what I heard you earlier is just, well, we don't want to give deference to the legislature. We don't want to give them an inch, even though they may be asking for a half mile or whatever figure you want to put on it. Is it legal, severability, or you just don't think it's a good idea on this one?
Thank you for that question, Your Honor. So even under normal circumstances, the law presumes severability just by statute to every measure, but that's never ended the inquiry. What remains must still be workable as what the legislature intended, and also recognizable as the law it passed. And so when I talk about recognizable and consistent with legislative intent, what I mean is not trying to get in the heads of the legislature, but the intent based on evidence. What did they put in the four corners of that act? And if you've struck down so many provisions, does the before and after photo look the same, or do they look entirely different? And if they look entirely different, that's not the same law. That's a law created through the court system, through the judiciary, and at that point, judicial restraint is striking it all down.
I'll tell you, I'm not going to try to get in their head, but you tell me, so would you say 6 out of 15, 8 out of 15?
So here we have an interesting situation where we have a central piece to the legislation. We have the county caps. If you looked at the floor debates, 95% of it was about county caps, and it had a specific rationale. It was sold to them as something that would help rural folks. I think that's dubious, but that's how it was sold to them.
Let's just focus, if you would, generally for me. You want to kill the whole thing. I know
Yes,
it's
Your
what you want,
Yes, Your Honor.
but you're telling me it is legal. Severability is a possibility, and they're going to argue it.
Oh, yes, Your Honor.
Okay. Good. Thank you. I
Thank
know
you,
you
Your
could
Honor.
go on, but we're past already. Thank you, sir.
Thank you. Justice Kane.
Thank you, Chief. I want to return back to something that the Vice Chief and Justice Gurich both talked about, and that's the evidence issue. Now, if this had been presented to a court of first instance adjudication, we would have had a trial, and we would have witnesses, and you're indicating that that's not necessary, in your opinion, for this proceeding. Is that correct?
I think that it can be decided on the record before the court, and it's fully right for adjudication, Your Honor. That is correct.
And so what you're suggesting is that we have a trial by affidavit.
No, I think that this is primarily a facial challenge, and that every application of the county caps is going to be unconstitutional regardless of what the record says, and that's the same for many of these provisions, particularly the ones that are subject to heightened scrutiny, which is across the board.
Okay, well, let me kind of drill down a little bit on some of those facts. And if this is in the appendix, I apologize, but in the briefing, I didn't see the math done to support the contention that it would be impossible to proceed forward with some of these things. I think, for example, if an initiative fails, then within 3 years, you've got to get a 25% of the voters' approval, and you say that's impossible. And that you're a smart guy, you're probably right, but is that math ever shown anywhere?
Yes, it is. Yes, it is. It is in our briefing. If there's a 25% threshold and it applies to that 25% threshold, and you can only collect, say, 11.5 signatures, then that is an actual impossibility, and that's an additional reason to strike down the county caps. The county caps can be struck down for that reason alone.
So there's like an Excel spreadsheet that goes county by county and says, here's how the numbers work out, and the bottom line shows that that's still under 25%?
No, it's
or is that just
11.5
or is that just your ball?
That's just as a matter of math, Your Honor.
Okay, but there's been no evidence presented on any of these issues. It's all just, it's math, right?
Well, for that one, it is math.
Okay.
For the other ones, we do present some evidence about needing a buffer to get there. And as far as the original initiatives, an absolute impossibility is not the standard. We just have to show a burden that has a chilling effect on the right. And what I mean by chilling effect is so would a reasonable person be deterred from engaging in protected activity because of this law? And if you look at 1027, the answer has to be, yes, it does. People aren't going to invest the time, money, and resources to go and change the law if they're looking at all the burdens they have to face with 1027. And that is a burden in itself, and that is something that we can weigh against the state's asserted interests.
Okay, and your assertion is that there's 2.4 million registered voters, right?
That sounds correct, Your Honor. Okay,
and where did that number come from?
That came from one of our affidavits, who I believe look at the election board site, and I believe, and it's a public record. You could take judicial notice of it as well, Your Honor.
Okay, and there was reference earlier in the argument about urban and rural divide. Is it your surmise that the legislature was trying to level the playing field and make sure that the rural voice was heard as well as the urban voice?
I think that is exactly the rationale they used to justify this unconstitutional law, and I'm glad that you mentioned that, and I'm glad that you said leveling the playing field, because that is precisely what they said in the McCutcheon case, that is just not a valid state interest. The U.S. Supreme Court said, as good as it may sound and as desirable as it may be, leveling the playing field is simply not a valid government interest. And because of that, you can strike down this law as a matter of law with no additional record, Your Honor.
All right, and I think I had one more question. I may not. Thank you.
Thank you, Your Honor.
Thank you. Special Justice Huber.
Mr. Yates, so you're asking us to apply a strict scrutiny standard, is that correct, with respect to the caps?
With respect to the caps on our equal protection claim under the Oklahoma Constitution, yes, Your Honor.
All right. So under a strict scrutiny standard, would you agree with me that the process of collecting signatures, right, does the state have a compelling interest in that process?
The state has a very minor interest, and that was set forth in Buckley versus Meyer, and that framework is that state interests are absolutely minimal on the just circulation of petition stage. The Supreme Court said, look, all that's going on at this stage is speech and association. And so if you're going out and you're collecting these signatures, you're just building a critical mass to get something on the ballot, and at that point, everything is going to be subject to generally applicable election laws.
But this is direct democracy at its finest, right? The initiative process. We're ending the process of deliberation, right? There's no deliberation in an initiative petition. To pass legislation.
Just to get it on the ballot. Well, no, what the Supreme Court has said is that it's direct political interaction, completely protected free speech, and you have to talk about the merits of it well. So what the Supreme Court says is, yes, there is deliberation, but it's among the citizens.
All right. Now, isn't the initiative petition signature process part of the deliberation? Don't you claim yourself that going into the smaller counties, the rural counties, actually helps get voters familiar with what's coming up on the ballot and actually informs them and could increase the likelihood of a successful initiative petition?
I think that it could be, and I think that all proponents have a incentive to get it out, to spread the message as far as they can. And all proponents here welcome all signatures from rural counties, urban counties alike.
Isn't the legislature furthering that endeavor? Aren't they making the tent bigger? Aren't they increasing the information that voters in our rural areas are getting at the forefront? Because the reality is, under the old process, these signatures are going to the fair. They're going to these large areas and they're collecting as many signatures as quickly as possible, right? It's one of your complaints.
Correct, Your Honor.
Yeah.
You absolutely have to. You have 90 days. You need to get 1,000 signatures a day. You've got to go where people are.
Right.
Absolutely.
So that's an effort to collect as many signatures and as expeditious a way as you can. And I understand you don't like the 90 days, right? You think that's a burden.
That's not before the court at this time, Your Honor, but it is what expedites the process, and it is the main thing that requires them to need to go to where people are in the first instance, Your Honor.
But again, doesn't the government, by placing a cap, isn't that really the least restrictive alternative to ensure that rural voters are informed and are a part of the process from the get-go, rather than showing up on election day and seeing this state question on the ballot?
Not at all, Your Honor. If the state interest is to promote education, there are lots of ways to do it without burdening the right at all, and there are constitutional means to do it as well. The means that the state chose is the one that is unconstitutional. It relies on quotas and rationing. What the state could have done was use the mechanics of government. Do your own educational program. Ensure that signature sheets are supplied at, say, all city halls or county seats so that this can get out to rural folks. Those are things that the state could have done without burdening the right, and instead it chose an unconstitutional means.
Thank you.
Thank you, Your Honor.
Counsel, I have a follow-up question from Special Justice Huber's remarks and question. Are you able to give us the history of the 90-day signature gathering window? How long that's been in play?
It's not at issue in this case, Your Honor, so I think that I would be just speculating to answer that question. I'm sorry, Your Honor.
Thank you, counsel. Mr. West, you're recognized for 20 minutes.
Good morning, Mr. Chief Justice and your honors. May it please the court. It is very nearly undisputed here that in Oklahoma, initiative petition campaigns do not currently spend any substantial time seeking signatures outside of the major metropolitan areas. And it was eminently reasonable for the legislature to consider this discarding of suburban and rural Oklahomans a major issue worth addressing with Senate Bill 1027. Nevertheless, petitioners have repeatedly claimed, as they have today, that SB 1027 is subject to the strictest of scrutiny, or strict scrutiny. But this is mistaken under both state and federal law. Under state law, the Oklahoma Constitution, as we've talked about today, expressly requires the legislature to enact suitable regulations of the initiative petition process, as well as regulations to prevent corruption. And in Section 7 of Article 5, that is in the initiative petition regulations, it expressly preserves the legislature's right to act. It actually adds another preservation of the legislature's right to act. That's the only thing that Section 7 does. And I want to go back historically, maybe to put on my inner Bob Burke hat for a second, and say that I think it is actually important here. If we go back to 1908, in Ex parte Wagner, 21 Oklahoma 33, this court, just months after the founding, held that our state constitution's initiative, petition, and referendum regulations are not self-executing. They are not self-executing. That's been a holding that has been on the books in Oklahoma now for 117 years, that our initiative and referendum regulations are not self-executing, that the legislature, before any initiative right or any initiative privilege can be acted upon, our legislature must provide the details and schematics of the initiative process, which it has done here and it has done countless times in the past for 117 years. Thus, historically, this court has not applied strict scrutiny to initiative regulations. Rather, it has indicated that only unduly burdensome laws are impermissible, and has added, at least in one 1936 case, that this undue burden or any infringement upon the right must be obvious. It's used the word, it has to be an obvious undue burden. That's in Associated Industries of Oklahoma, 1936, Oklahoma 156, paragraph 36. It says it has to be obviously infringing upon the right. And in the same vein of deference to the legislature, this court has historically equated the word suitable with reasonable multiple times. It is used the word suitable and reasonable interchangeably in this context. So in a decision relied upon petitioners in this case, and I believe they just cited it in the oral argument, in re-initiative petition number 142, which is 1936 Oklahoma 209, in paragraph 35, this court said, quote, "This is a suitable provision of law, semicolon, it is reasonable, period." And that's not the only time that this court, in its history, has equated suitability with reasonability. Reasonableness is a far cry from strict scrutiny. And SB 1027 easily passes a reasonableness standard. What could be more suitable or reasonable than a modest effort to ensure that at least some Oklahomans from across the state get to participate in initiatives at the front end, at the signature gathering stage? To hold otherwise is declare that the numerous states with geographic restrictions, which is, I believe, numerically, somewhere around 15 or so of the 25 states that have initiatives have geographic restrictions, some of them statutory, that those 15 states are all just unreasonable, that they're all infringing upon the burden and the right. That's what their argument would have to basically conclude, is to say, well, all these other states, geographic restrictions, their initiative processes are being unduly burdened, all of them, and it's unreasonable. That hasn't been shown, and it's simply not the case. This leads to federal law. Petitioners challenge the county caps under the First Amendment. But if petitioners' federal arguments were sound, then presumably, again, these 10 to 15 other states with geographic restrictions, those all provisions would have been enjoined. They'd be unconstitutional as well. And plaintiffs have not cited, and we did not actually realize this case existed until fairly recently, the 10th Circuit has actually upheld Colorado's geographic restrictions against an equal protection and a First Amendment challenge. That's the case Semple versus Griswold, S-E-M-P-L-E versus Griswold, 934 F. 3rd, 1134. It upheld Colorado's geographic restrictions against a federal equal protection and a federal First Amendment challenge. And Colorado's restrictions are arguably more onerous than Oklahoma's because they require a certain number of signatures to come from all 35 Senate districts in the state. They require you to go into all 35 districts, whereas SB 1027 does not require signatures from all 77 counties. In fact, far from it. By our calculation, a statutory initiative could pass with signatures from as few as 16 counties. Importantly, the 10th Circuit held that geographical restrictions were merely, it expressly called them a process regulation, and thus said that strict scrutiny does not apply. And moreover, that court wrote, and I quote, "This court has previously addressed and rejected the proposition that the First Amendment is implicated by a state law that makes it more difficult to pass a ballot initiative," end quote. The Ninth Circuit has come to a similar holding in a case called Angle versus Miller, 673 F. 3rd, 1122. It upheld Nevada's geographic restrictions that were statutory, not constitutional, and upheld them against a federal First Amendment and equal protection challenge. The Ninth Circuit held that Nevada's restrictions, quote, "likely increased the amount of speech on public issues by requiring initiative proponents to carry their messages to voters in different parts of the state," end quote. And that's exactly the legislature's view here. Petitioners in their amici essentially claim that signing a petition is just as fundamental of a right as voting. This is incorrect both legally and commonsensically, but even if it were true, this means that rural Oklahomans have been experiencing one of the most egregious violations of a fundamental right in this state's history. Think about it. If any court were presented with a scenario where for 50 years, the only Oklahoma polling places, like voting booths, have been in Oklahoma City and Tulsa, this court, it would be deemed a crisis by this court, by the legislature. It would be deemed an absolute crisis that there are only 2 voting places and that the rural citizens have had to travel to Oklahoma City and Tulsa to exercise their fundamental right. If this is a fundamental right equivalent to that, then rural Oklahomans have been discriminated against for countless ages based on the signature process not ever actually reaching them. Petitioner's own rhetoric collapses on itself. Of course, the county caps are not the only regulations at issue here. Petitioners have kind of taken a kitchen sink approach, making it somewhat difficult to analyze any given provision with the depth needed. As we pointed out in our response, if this court is inclined to grant original jurisdiction, we think this would be an appropriate case for more robust briefing, fuller briefing. In any event, SB 1027's other provisions are based on important interests. Accuracy and truthfulness in ballot initiatives are plainly a compelling interest. The gist regulations in this law are similarly phrased to this court's precedents, repeatedly striking down initiative efforts due to inaccurate gists and repeatedly striking them down based on statute, saying that the statute requires this gist to be accurate. We're striking it down. And the legislature has largely copied a lot of that language from this court's decisions. Their argument here would essentially mean that the gist itself is unconstitutional because the gist was not required by the legislature until, I believe, 1985. And if that's something that the government can require, then their burden analysis and argument with an idea that, if it is government speech, it's the government interjecting its own speech would seemingly indicate that The gist is just, since 1985, has been an unconstitutional imposition on initiative petitioners. I think same goes for their argument, as has been pointed out, that they clearly take issue with the 90 days. And I think if you take their analysis and truly apply it to the 90-day provision, I think that would probably be found unconstitutional too under strict scrutiny. We wouldn't concede that. I mean, we would certainly argue hand and foot that that's not the case. But it's hard to see their extremely high burden and high standard would not apply to other provisions like 90 days or almost anything the legislature's done for 117 years. But that's just not the approach this court has taken. And again, as we pointed out, and I don't think petitioners have ever offered an answer to this, if they're right about the gist, then they have seemingly a right to politically advocate in the gist and potentially even to mislead. Obviously, the First Amendment protects, in general, if you're out on the public street, it doesn't allow people to criminalize misleading speech or somebody who's skewing things in their favor. I don't believe that's the approach this court has ever taken to a gist, and I don't think that that is an approach that any court that I can think of, because there are numerous states that have similar gist requirements that require truthfulness, accuracy, impartiality, etc. Indeed, in one, and I do want to point this out, there's a California case that we've cited in our briefs. It's the San Francisco 49ers case. And in that case, the court actually found, it didn't find that it was government speech. It said, we think this is a non-public forum. In a non-public forum, the government, this court actually just wrote about this in one of the Durbin cases, or the Durbin case, I think, mentioned a non-public forum and said if the government creates a non-public forum, the government can limit the speech in that forum for the purpose of that forum. And I point that out because this court held back in 2016 in an INRI initiative petition number 409, it said that the gist is, quote, the only shorthand explanation, end quote, provided to potential signers. And more importantly, it said that this court held that the entire, quote, purpose of the gist, the purpose of it, is to, quote, prevent fraud, deceit, or corruption. So this court's holding is the legislature enacted the gist to, the purpose of it was to prevent fraud, deceit, or corruption. So even if this isn't government speech, if it's like a limited public forum, well, the purpose of the public forum is to prevent fraud, deceit, or corruption in the gist. Ergo, the state in that limited public forum is subject only to rational basis for making sure that you're actually preventing fraud, deceit, or corruption. Various appellate courts have upheld prohibitions on pay-per-signature models, including the 2nd, 8th, and 9th circuits, as well as the Arizona Supreme Court. As these courts have found, pay-per-signature incentivizes some of the worst fly-by-night practices in this arena. And then the reporting and disclosure requirements, they're far narrower than petitioners admit, and they have case law supporting them as well. The Supreme Court's 1999 Buckley decision, the decision on which our correction was based, and the decision it expressly says, and the decision they've claimed today favors them, it expressly says that the state legitimately requires sponsors of ballot initiatives to disclose who pays circulators and how much. I'm going to read that again. The state legitimately requires sponsors of ballot initiatives to disclose who pays circulators and how much. That's almost approving of one of the provisions of our law. That's Buckley from 1999. And I believe the claim was made here today that Buckley says that the state's interest in the initiative process is limited, but if you look at page 204 through 205 of Buckley, the court says that Colorado can and does meet the state's substantial interests in regulating the ballot initiative process. Colorado aims to protect the integrity of the initiative process, specifically to deter fraud and to diminish corruption. That the state, in other words, the state has substantial interests per Buckley in the entire ballot initiative process. Petitioners have claimed that there is a lack of evidence here, largely, again, kind of ignoring the 4 declarations from the state. It's petitioners who have the burden here, not the state, and it is their evidence that amounts largely to speculation, as I believe Justice Kane was pointing out, that there's a lot of gaps and unknowns, and it is not the case that they've shown impossibility for the county caps. They focused on the one provision, I believe that was Section 6, that the state in our brief has disclaimed the county caps even applying to that provision, because if they did, it would truly be an impossibility. So it's our view that the legislature did not intend for them to apply to the specific 25%. But on the regular process, the 15% process, there has been no showing of impossibility. State's witnesses testify in their declarations that it's not impossible, And I believe the petitioner's own declarants really fall short or stop short of saying this is truly impossible. Finally, and on the evidentiary point, the state certainly would agree that if this court were to accept their arguments, that there would have to be an opportunity given to the state to actually produce evidence to meet even higher scrutiny. Like, that's part of the scrutiny process. The state is given a chance to produce evidence to meet higher levels of scrutiny. So while the state does share some agreement that, and we're on the opposite side of it, obviously, but we do agree that certain provisions potentially can be decided as a matter of law. But we also recognize that, yes, a lot of the case law in this area speaks about evidence, speaks about trials, and that it would be perfectly appropriate for this court to deny original jurisdiction and say there needs to be a record produced here, an actual trial, discovery process, and record. In the end, SB 1027 is not clearly, palpably, and plainly inconsistent with the Constitution. And one of their briefs, and I believe even here, they've kind of alluded to saying that that standard doesn't apply or shouldn't apply to initiative petitions, but that's foreclosed by this court's precedent. In Kiesel versus Rogers, 2020, Oklahoma 65, in paragraph 6, this court made clear that the petitioners there, who were arguing for an undue burden on the initiative petition right, still have a, quote, heavy burden that requires a showing that the statute is clearly, palpably, and plainly inconsistent with the Constitution. And then this court emphasized that, quote, every presumption in the initiative case is to be indulged in favor of the constitutionality of a statute. Every presumption in the initiative petition context, that standard still applies here, just as it applies in every other act the legislature passes. Here, the standard counsels for upholding SB 1027 because it is not clearly, palpably, plainly, or obviously inconsistent with the Constitution. Thank you. I'll accept any questions.
Thank you, Counsel. Vice Chief Justice.
Good morning, Counsel.
Good morning.
All right. I just like to direct people where I'm going first. I don't have very many questions. Let's talk about this evidence thing that you've been talking about. And to me, this comes down to, do you believe that the constitutional provision that says carrying into effect the provisions of Article 5 applies to all of Article 5? First question.
Yes, that is I would believe would be our stance, that applies to the entirety of Article 5.
Okay. So then it comes down to whether or not that phrase means the legislature can protect the birth of the initiative petition here and what its purpose is. But again, this is a legal circle a little bit, right? Because you can't, if we're going to interpret it that way and that it doesn't have to be a constitutional amendment, this is in place to make sure the legislature isn't being corrupt and trying to eliminate the initiative petition process because they don't like it when the people want to go around what they won't do. But when we get to that, counsel said something interesting. He said, well, not only is it corruption, but it's to get the majority viewpoints to a vote that the legislature won't put to a vote because it's the majority viewpoint of the voters. So is there any evidence, or would it be interesting for this court to consider that majority viewpoints are now what is the initiative petition driven policy in this state, with or without corrupt, money or stuff like that? I don't know if there's any proof of that at all. But if there are minority viewpoints that are like, well, hey, we can just go here and we're gonna get this stuff on the ballot because we can't get the legislature to pass it. Is that something that is in the record that is proven that that's a problem? If you may get my question, is there any evidence in the record that that's what's happening and that it's a problem and that it is going against the policy of what the initiative petition is in place for?
Respectfully, Your Honor, is it in the record? Is
here in front of us that the legislature or the law, the initiative petition process at this point in the existence of Oklahoma because of population is no longer functioning because it's not putting forward majority viewpoints and putting forward what are minority viewpoints possibly. And at the end of the day, there are examples, I think, of some of those things, criminal with criminal law things that people are like, you guys need to do this with criminal laws in Oklahoma. The legislature's not doing that, and I think it went to the people and they voted it in. Recreational marijuana, that might be an example. But are there any other examples of things that the legislature thought, well, that's not a majority and we're not passing it? So, and do you understand what I'm saying?
I think I'm getting there.
I'm
yes.
sorry.
So no, it's fine. It's on me. I don't think there's any evidence in the record that the legislature, at least certainly not the evidence you would need, the level of evidence you would need to somehow prove that the legislature is trampling upon the majority view in Oklahoma. I think that would be an extremely high burden that somebody would need to produce.
But that they would be saying that this is to protect against a minority. He argued that it's for a majority viewpoint to go to the people. Is it flipped? Is it now because it's what can't be passed by a majority of the legislature that minority viewpoints are getting put in front of that? And is that what the initiative petition is for? And is that okay? I mean, that sounds fair.
In terms of the purposes of the initiative petition, I think the actual text of the Constitution doesn't mention majority or minority viewpoints at all. I think it...
So his argument that that's part of the initiative petition consideration is not correct.
I don't think so based on the text of the Constitution. At least that's not in the provisions explicitly spelled out that this is about majority minority as much as it's about legislature, which represents we the people, but then also
I thought it was just about them protecting against corruption. But that's why I'm very interested in this concept that it's also to put majority viewpoints to the people if they won't go be passed by the legislature. But that could be true or not. Okay, one more question. So you said the petitioners have the burden, and I agree. But then he argued, and I think if we do strict scrutiny, it is going to be on you to produce evidence too. So is there anything about even what Justice Kane is saying that you're like, hey, we would, if that's the burden you're going to put on us at this point, we would like the opportunity to present evidence even on a remand to district court for that kind of conceptual evidence collection for you? Is that what you're arguing?
Yes, that's our point, is that if a heightened standard is applied such that it can't necessarily be met by us as a matter of law, but it would be can you meet this strict scrutiny or not? Yes, our view would be we should be given a chance. Like we appreciate our affidavits here and we think they're fairly robust, but they were still produced in 2 weeks. Like this isn't a case where we've had a chance to do discovery or actually meet that type of heightened standard. Now, of course.
Now, wait, because I agree. Like, I think Justice Gurich asked a legitimate question of counsel, and I'm not trying to insinuate that you need evidence for us to interpret whether or not effective the provision is what that means. But if the evidence that I'm questioning everyone about is when you then have a standard that you have to do for not review, but a level of scrutiny, that's where the evidence comes in the record, because then we'd have to determine whether or not you're meeting that level of scrutiny. Yep. So that's the evidence that I'm asking you if is appropriate for us to consider, and if you've had an opportunity to provide that.
Yes, that would be appropriate if it is heightened scrutiny to consider our evidence, and no, we have not had a full opportunity to provide evidence in this case. The one caveat I would add is if it's a lower level of scrutiny, such as a reasonableness or rational basis, courts have repeatedly held that state laws can be found and upheld even without a production of evidence on lower levels of scrutiny, which is one reason why we've said we think we could still prevail as a matter of law here, because we think the lower levels of scrutiny do apply. But if heightened levels of scrutiny are applied, then we do think the state is basically in the legislature. The deference to the legislature is entitled to have an evidentiary case put on in its favor. And we will acknowledge it's not, maybe not our preference, but there are quite a few of the cases in this realm that, again, you look through their background and history, they had trials, they had evidentiary proceedings, they had more than what has been done here. We would prefer to prevail as a matter of law. And we do think we have strong arguments for doing so, but it is impossible to deny that quite a few of the cases that are cited by both sides here, when you go look at their backgrounds, have evidentiary productions of some sort that are fairly robust.
Right, I waive.
Thank you. Justice Winchester. Justice Combs.
Sorry.
in this particular case, there's been a lot of discussion and questions about developing an evidentiary record in order to meet your burden. This is a case also where there was a request for a stay by the petitioners while this matter worked its way through the court with us. In the event that it goes back and there's a request for an evidentiary record, which is going to add significant time, what's your position on the stay?
We would still oppose the stay for the reasons we've laid out in our briefs and at argument here. The stays usually depend on several factors, but the main factor is likelihood of success on the merits. And so we would argue that the state has shown a likelihood of success on the merits. Now, obviously, opposing counsel, who is a good friend of mine, I'm sure they would argue that they're likely to succeed on the merits. But I do think a stay shouldn't just be automatically issued. I think a stay requires this court to walk through the four factors, the first of which is likelihood of success on the merits. And again, we feel like we've put together very strong arguments based on case law and based on precedent for why the state is likely to succeed on the merits here.
The statute creates a maximum for signature collection, correct?
Yes, correct, per county, correct.
Per county, signature collection per county. And part of the argument here is it disenfranchises an individual Oklahoman from another Oklahoma, correct? That's the argument.
Yes.
So what you're really saying, and I think you've argued this in some of your briefing that I've looked at, that it's not that you can't sign the initiative petition, but it doesn't count.
Yes,
once you reach a point, it doesn't count. You count, but you don't. And how is that not disenfranchising the you don't person?
It's a very fair question, Your Honor. Our argument would simply be that yes, unlike a lot of their arguments are based on the buffer question. They're foundational. I think there was one, their affidavit from Amber England said that is the key provision that the not allowing of a buffer. And we have argued, so it's the perception of the position of the state that no, buffers are allowed. The statute says nothing about buffer signatures, does not prohibit buffer signatures. So one of our arguments in response to that would be to simply say, you count, you don't, is that is a lot more fluid than it seems based on their argument based on no buffer signatures. Because our argument would be everybody can sign, and it's often not clear until signatures are actually gone through the process how many signatures you need. So it's very likely when you're signing, your signature almost certainly could still count. You wouldn't know, oh, it doesn't count, or it definitely is not going to count. Because I think the statistic they brought up in their affidavit was that they think that signature success at the end of process is only at most like 72%.
Well, let's talk about that. I'm going to interrupt you there for a moment.
Oh, no, fine.
And that's talking about when you're trying to qualify the signature, one of the things this does is it increases the data points on the signature. Does it not? It goes from 3 to 4?
No, I think that was a previous bill that increased the data points.
The point being that the signature isn't verified until that data point has been complied with. So if you cut off what's collected, and then you have this, well, you may need more, you always want to get a cushion so that you make sure that you have enough in the 76th county to cover county number 1. That's problematic to me. I don't understand how the state can legitimately argue that you can sign it. It's an initiative petition, not a vote, but an initiative petition. You can sign it, you count, you don't. That's a problem for me. Thank you.
Appreciate it, Your Honor.
It's not a question.
Oh, no, I understand. Yeah.
Justice, thank you. Justice Gurich.
So in your recent filing, you acknowledge that the U.S. Supreme Court has struck down registered voter restriction on circulators.
Yes, Your Honor. That was in the Buckley case, and we apologize for
no, and
for that.
I'm not being trying to show blame. I'm just saying you've conceded that that's part of this statute.
Yes, Your Honor.
It's not a residency deal. It is a registered voter. So that leads me to a question about severability, and I think you've advocated that. So why don't you tell me what so we agree that would have to be severed, right?
Potentially, yes, Your Honor. There's a lot of potentially strange postures that could come from this. So it's possible, Your Honor, that it would not necessarily need to be severed by this court if this court decided, for instance, to just send the whole case to the district court.
We'd save that for another day.
Save that for another day.
Okay.
And on top of that, given the concession and the correction that we've made, We haven't had those discussions because that's been very last minute, but I assume we will soon have discussions about, the enforceability of that provision, given that it does seem squarely on point with what the U.S. Supreme Court held.
Okay, and
So
you've
it may-
also got problems, don't you, with restricting who can contribute to an initiative campaign? Hasn't there been subsequent U.S. Supreme Court cases that tell us that you can't restrict political speech, that money equals political speech?
Your Honor, I think those cases are distinguishable because they're broader in the laws in question discuss campaigns or independent expenditures, for instance. So, for instance, I believe it was the Bonta case out of the Ninth Circuit that came out of California. Although that wasn't necessarily expenditures, that was more disclosures. But point being is that it's still broader than Oklahoma's law. But no, we think that the expenditures here, it says you cannot fund circulators. It's not funding a campaign, it's funding the circulators in particular. You cannot fund circulators unless you are a registered voter, resident, or doing business in Oklahoma. And that is extremely broad, actually. That allows a lot of funding. It simply says that somebody who has no ties to Oklahoma, not even doing business here. And as far as we've seen, there's no case that's even close to directly on point with something that broad that allows that much participation from outside groups.
Then let's turn to caps, because you keep mentioning Colorado and you mentioned some others, but this is not a constitutional amendment. No one's arguing here that the voters in the state could not amend their constitution to include some of these things that perhaps have been upheld based on other challenges. The issue here has more to do with how much of a restriction, how much of a burden, and regardless of whether we go to strict scrutiny, the undue burden, I think we've all discussed that several times this morning, at some point the burdens pile up and it becomes an undue burden. And so that's the concern I have, is that it's not that maybe some of these provisions would not stand up under a constitutional challenge if they were part of our Constitution, but that this is where the legislature has gone beyond implementing, carrying out, preventing corruption. How do you respond to that?
I would respond. I think you have to look through it, at it through two lenses. One, for their federal challenges, I think it really doesn't matter whether it's statutory or constitutional. In other words, like I said, another state's constitution that has geographic restrictions that are impermissible under the federal constitution are just as impermissible whether they're in the constitution or in the statute. So we think the case law discussing federal equal protection, federal First Amendment challenges are just as applicable to Oklahoma, whether it's statutory or constitutional. The federal law doesn't, for lack of a better way of phrasing it, federal law doesn't really care whether it's in your constitution or your statutes. And then I think at the state level, the question of whether this is permissible, it does come down to just what this court thinks of suitability, of undue burden and suitability. That's, I think, the question in the case on each of the provisions that have been challenged under the state constitution, but under the caps is it suitable for the legislature to say that this 15% needs to have a modicum of support, from a modest level of support from not just the majority urban areas, but from around the state? Is that suitable for the legislature? Our argument is that we think it is very suitable, very reasonable, and part of it is based on our view of the standard, which I walked through in the beginning, of saying it's not a self-executing provision. The legislature is allowed to fill in details. The legislature has historically been given a lot of deference from this court on reasonability, but that is the question.
All right, I have one more question about the gist. Many of the things that you mentioned indicated what our court has done in the past to fashion a gist challenge to make sure that it's not misleading, that it doesn't show any type of corruption, all of those things. But this shifts from the court to an appointed official of the governor. This is the concern I have. It's not that there shouldn't be restrictions. It's more, how do you, when the governor's been basically eliminated from this process by constitution, you have a governor who's now going to control the content of the gist. A
couple of points, Your Honor, on that. First, I would say that having executive officials overseeing something like this is fairly commonplace throughout Oklahoma history, and it's commonplace in other states that have initiative petitions. There's, California, Missouri.
But we're talking about Oklahoma.
Yes.
We're talking about a very suspicious group of people who created the Constitution in this state. And so we don't need to go to other states. This is my concern, is how does this pass constitutionality in this state?
In this state, because having the Secretary of State or the Attorney General, for instance, involved in the ballot title process, which is very similar, has been routine and normally done. Our office plays
This is not ballot title. I'm not arguing ballot title.
But the ballot title is still, it's a similar idea. The idea that, and again, the gist is a legislative created entity, and if the legislature wants to create it and put the executive branch in charge of enforcing it, that's fairly basic in the separation of powers in Oklahoma. And the last point I would make is, to the extent there are concerns about shenanigans on the part of some secretary, that is perfectly appropriate for an as-applied challenge. But as my opposing counsel has said repeatedly, they're bringing a facial challenge. And facial challenges, as the U.S. Supreme Court has recently acknowledged, are, quote, hard to win. That's the Moody case from the U.S. Supreme Court. Facial challenges, you have to show that it's inapplicable in almost every instance.
Okay, thank you very much, and I waive.
Thank you. Justice Darby.
Counsel, you're arguing, I think, that the rationale behind the caps is to involve more folks, more counties, right?
Yes, Your Honor.
Still going to be some people left out, wouldn't you say? Areas left out?
Yes, Your Honor. That's why we have described this provision as relatively moderate. It doesn't require, unlike, say, Colorado, which requires you to go into 35 Senate districts, at least my understanding of that law, Oklahoma's, by our calculation, to get at least the minimum amount of signatures, could only require as few as 16 or 18 counties to be gone into. But that does extend past the major metro areas of the state. So in our view, the stretch of it is relatively modest.
So the folks in, say, Harmon County, how many signatures are we going to get out there?
I do not know off the top of my head, Your Honor, how big Harmon County is or what the tabulation.
None.
Potentially, or potentially could be some.
None. So you're just widening it to maybe other smaller cities in Oklahoma City.
Potentially, yes, but I do think it is going to require
potentially anything.
Yeah.
I don't care about that. Thank you.
Thank you, Your Honor.
Justice Kane.
Thank you, Chief. Yeah, I think I alarmed Mr. Yates a little bit. I do take judicial notice that 11.5 is smaller than 25. 20.8 is as well. But that's 11.5% of apples compared to 25% of apples. And especially at the 20.8, it's 20.8% of the people that voted for governor several years ago as opposed to 25% of the people registered to vote today, I think. And I just wondered if that math had ever been done. And it hasn't, has it?
I don't believe so. I believe, at least on the core provisions, well, I do. Let me rephrase that. I don't believe the math has been done to the extent that you had referred to earlier with Excel spreadsheets and laying everything out thoroughly. I know because I don't want to underplay it either. Amber England, in their declarant, did lay out numbers. Our declarant, Rick Farmer, came back and pushed back a little bit, but agreed with some of the numbers and calculated and kind of gave summaries. But it was not a comprehensive laying out, I don't believe, on either side. So, for instance, I believe, and for instance, our affidavit with Rick Farmer, that there was, again, kind of a summary of kind of highlights of the numbers, but it certainly wasn't a fully comprehensive view of the numbers. So I don't mean to say that no numerical calculations have been done on either side. I just mean to say it hasn't been fully comprehensive.
All right, thank you. Now, I believe counsel for the petitioners had suggested that U.S. Supreme Court law would prohibit a measure to, I believe, level the playing field was the phrase I used. Do you agree with that?
No, I don't. We would not agree with that under, I believe the McCutcheon case was cited, but I have not looked closely at that case, but I believe it's distinguishable. I don't think it's an initiative petition type case. And I think, again, that argument taken to its logical conclusion as a matter of federal law would mean that the 10, 15, however many states that have geographical restrictions, they'd all be unconstitutional. If you're not allowed to do some sort of encouragement statewide of efforts to get initiative signatures, I don't see how the numerous geographic restrictions out there, some of which we've discussed in our brief, some of which we haven't had a chance to get to, like Nevada, I don't see how those could be constitutional under a really strict ruling that, that you just can't do that.
All right, thank you. Chief, I'll waive.
Thank you. Special Justice Huber.
Sir. In the briefing, there's been discussion about, related to this, State Question 788. You're familiar with that?
788.
Medical marijuana.
Okay, medical marijuana. I was about to say, I sometimes those numbers run together in my head, but I am a little bit familiar with that one, yes.
Would government involvement in editing or controlling the gist have made a difference in that case? Were rural Oklahomans duped in the initiative process in the face of that state question?
I don't think I can answer that either way. I don't have that gist in front of me. I believe my answer is I don't think so, but I don't know for sure. I haven't researched the gist of that question. And
well, can you give me examples of previous state questions where government involvement in controlling the language of the gist would have made a difference in a positive way, in a way that the government has a compelling interest to control?
I don't believe I have any example off the top of my head, Your Honor, in terms of Oklahoma's gist and language. I know that, and part of that is because this court has pretty rigorously regulated the gists. So I would say that there's been a number of cases where this court has struck down a gist. Those would be examples of gists that were not crafted well. And our argument is simply that if the Secretary of State does it even further ahead in the process before it gets to this court, that A, could alleviate some pressure on the court, and B, it's appropriate for the Secretary of State to do it with every petition, do that same kind of review that this court has done repeatedly on the gists. So is there an instance of a gist that's gotten past this court that shouldn't have? I can't think of one, but that's in part, like I said, the legislature's language is largely mirroring what this court has said is required from gists and saying, okay, Secretary of State, you do that at the front end and make sure these gists are accurate, truthful, impartial, etc.
So your position, it's helpful?
Yeah, it's reasonable, it's helpful, and it complies very easily with this court's precedents and language on gists, where this court has said, yes, they need, the purpose is to prevent fraud, deceit, corruption, they need to be truthful. And this law basically just says, okay, well, we want this, that is true. The legislature agrees with this court, so we're going to put the Secretary of State at the front end checking the gist. And it's not that the Secretary of State is going to be doing it without oversight from this court. If there's disagreement, this court can be resolved to and come to with as-applied challenges. And this court, I'm sure, will, if this law is allowed to stand, will take up such challenges in the future.
Well, then where's the problem with the old system? Because I read where this argument that specifically the medical marijuana bill has had this negative effect on rural Oklahomans, and that they weren't aware of what they were voting for, and that it's buyer's remorse, and that the process itself was the cause of that. Had they known what the medical marijuana bill really did, they wouldn't have voted for it. Isn't that one of the arguments?
Yes, but I think that argument pertains probably less to the gist, because honestly, I doubt many rural people ever saw the gist in the medical marijuana case, since it's, again, nearly undisputed that the gists are only circulating in Oklahoma City and Tulsa. So maybe, I think the argument of the legislature and our argument is that part of the problem is that First Amendment speech, that the speech that needs to happen among citizens or throughout the state is not happening in advance of these bills. So the rural peoples aren't seeing the gist. They're not informed until the moment of the vote sometimes what's actually being voted on. So they're not participating in the process leading up to it, which means they're not being fully informed. And the legislature has a compelling interest to ensure that the citizenry, in advance of huge questions that have immense impacts, are better informed or fully informed, or at least more informed.
And then I have a question about this notion of collected versus counted. Under the old system, wasn't it the same? You don't know if your vote's counted or not. If I sign at the fair, how many votes have you collected versus how many you need? And that process isn't coordinated until the end, is it?
No, I think that's correct. And I think a lot of petitioners' complaints cast doubt on the current system, where they would say, yeah, under the current system, 85% of people under the current system don't have any say if you meet the 15%. But even to meet the 15%, yeah, there's people whose votes are going to be, or not votes, whose signatures are going to be counted. There's people whose signatures are not going to be counted. And oftentimes, because you maybe don't determine that until later in the process, they're not going to know. So the current system has many of the same indicia that are condemned under the updated system. It's really not that big of a difference between the two systems.
Thank you.
Thank you, counsel. Mr. Yates, you're recognized for a 4-minute rebuttal.
And if I could just say one final thing, not substantive. I just want to thank this court. I've been arguing and filing briefs here for 10 years, and this is the first time I've had an opportunity to appear en banc. And so thank you. It's been a pleasure.
Thank you, counsel.
If I could echo that. Zach and I started the same day at the Attorney General's office, and we've been filing for a long time here. But I want to push back on some of his arguments regardless. I think that we should look through not multiple lenses, but one lens, and that is the Oklahoma Constitution here, and the Oklahoma Constitution protects that right to every legal voter, period. Number 2, on the gist statement. They made a whole bunch of complaints about the gist statement, but let me tell you what the gist statement is. It's a compelled disclosure, and compelled disclosures must be accurate and non-controversial under the First Amendment. It also serves an anti-corruption rationale, as this court has recognized, and most importantly, it leaves the message in the hands of the people. There were multiple questions about the Attorney General's office not liking the outcome of votes and blaming it on rural folks. Those are arguments. Those are policy arguments against democracy itself, and I don't think that we should be engaging that at all.
Counsel,
and I want
if
to
it
leave
was
this.
constitutional for the legislature to require the gist, why would it be unconstitutional for them to change the gist and add different requirements to the gist? Counsel said that the legislature made the gist a requirement by statute in 1985. It's not constitutional. What's your response to that?
My response is that you have to go through the compelled disclosure analysis under the First Amendment. Are you asking for accurate, non-controversial information? And under the Oklahoma Constitution, does it have an anti-corruption rationale? Going back to the First Amendment, does it leave the message itself in the hands of the proponent so it's not altering the core message at a point of advocacy, Your Honor? And if I could just close with this, Your Honor, I want to say that we should assume original jurisdiction now because delay itself is causing the harm, and it's due to the chilling effect, the recognized concrete injury on a fundamental right. The uncertainty surrounding Senate Bill 1027 affects every legal Oklahoma voter that wants to propose a new law or to even sign a petition to put his name on the ballot. This law is deterring people from planning, fundraising, and engaging in the process that their Constitution reserves to them, in turn depriving citizens of the ability to debate and resolve matters of statewide concern. That is the political marketplace that is protected by the First Amendment, and why barriers to even get on the ballot are so important. So for that reason, this is not just an Article 5 injury under the Oklahoma Constitution, it is a First Amendment deprivation. The United States Supreme Court in Elrod v. Burns said that loss of First Amendment rights, even for minimal periods of time, unquestionably constitutes injury. That injury is happening now, not just to these proponents, but to all citizens statewide. Delay perpetuates the very harm that only this court, exercising its original jurisdiction, can prevent. And with that, Your Honor, I yield the remainder of my time.
Thank you, Counsel. Vice Chief.
Oh, I have no questions. I wait.
Justice Winchester. Justice Combs. Justice Gurich. Justice Darby. Justice Kane.
Chief, I just want to thank counsel for both sides for what I found to be a very helpful oral argument. Thank you both.
Thank you, Your Honor.
Special Justice Huber.
Waive.
The court would thank both counsel for your excellent presentation. We appreciate your preparation and your professionalism, and the court is in recess.